In 1911, Congress greatly expanded the reach of the Forest Service when it passed the Weeks Act.
To create eastern national forests, for the most part, the Forest Service would have to purchase private land. And there was some question about whether there was jurisdiction federally, constitutionally, to do that.
And so a constitutional hook was required before the Forest Service could acquire eastern forest lands. The hook was found in the Commerce Clause in the United States Constitution.
Forest Service attorneys argued that the protection of forest watersheds benefited interstate commerce.
Forest Service attorneys cited Forest Service research that showed a connection between deforestation and the navigability of waterways.
The Forest Service would be protecting the water flow, which would be protecting streams, which would be protecting navigation, which would be protecting commerce. It was somewhat of an arduous relationship, and it was deeply, deeply challenged at the time, but it was a part of standard beliefs, and it succeeded.
And so, over the next several decades, the United States would begin to buy up the cheap cutover lands of the East, South, and Lake states.
States in the Midwest and the West opposed the bill because they saw large amounts of funding going to the East rather than to the West. And the way the pot was sweetened in order to curry their support for what was basically an Eastern bill was to attach to the Weeks Act the beginnings of enormously important and rapidly developing Forest Service support for cooperative programs with states on fire suppression and research and insect control and other similar programs.